once again. Welcome to our channel. This is Dr. Olu Asekun here. Thank you again for joining us. Remember to invite family and friends and join us every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That will be 1 p.m. Eastern Time, and that will be currently 6 p.m. Nigerian time. Remember to log in every Wednesday as we discuss important immigration solutions to a lot of problems. On this channel, we try to explain immigration laws. We answer questions, all questions relating to immigration laws, depending on the topic we are discussing. And it is free of charge. So all you can do is to invite your family and friends to join us every Wednesday. Recently, we started removal defenses, and we are continuing in that order today. And today, we'll be discussing cancellation of removal for legal permanent resident. Cancellation of removal for legal permanent resident. That is what we are discussing today. We started the cancellation of removal series about 2 weeks ago. We discussed the cancellation of removal for non-permanent residents. We discussed the cancellation of removal for victims of abuse. And today, we'll be discussing cancellation of removal for legal permanent residents. Now, today's topic is a very, very complicated topic. Even for lawyers, it's complicated. So I don't expect a lot of questions, or maybe I will expect more questions in view of the complications. But it's a very, very, very technical area of law. Cancellation of removal for legal permanent residents. It is very interesting because as recently as 2020, during COVID lockdown, even the United States Supreme Court is still setting precedent on the requirement of cancellation of removal. So it is that complicated. So it's not something that is static. And that is why it is very, very important that we pay attention so that we don't misunderstand it. It's a very, very complicated area of law. And it is something that is changing. So if it is something you have not done, even as a practitioner, as an immigration practitioner, if it is an area you have not delved into in the last 3, 4, 5 years, I mean, things may have changed. So you need to update yourself. So now, when we are talking about cancellation of removal for legal permanent residents, we are talking about green card holders. In one of our prior podcasts, I did mention that having a green card is not in itself immune. Somebody with a green card is not immune to deportation or to removal from the United States. Basically, a permanent resident or a green card holder who commits a crime can still be removed from the United States, especially if the crime is what is called aggravated felony offense or drug offense, or even multiple misdemeanor offense, for as long as it's not more than, it's not one, but multiple. So a green card holder can still be removed or deported from the United States if any of these offenses are committed. So, but before a green card holder can be removed from the United States, there must be what we call final administrative decision. That means that the green card holder must have been placed in removal proceedings. Notice to appear must have been issued for that green card holder. The green card holder must have pleaded to the NTA the notice to appear. The court must have found that the government has met its burden regarding the notice to appear, and then the immigration judge will have given the green card holder an opportunity to ask for a relief, an opportunity to apply for a relief. Now, one of the reliefs that a green card holder could apply for when in removal proceedings is cancellation of removal for permanent resident, or in legal term, we call it EOIR 42A. EOIR 42A is the same thing, but only immigration attorneys will understand what that means. But in a layman's term, cancellation of removal for legal permanent residents. So that's what that means. So permanent resident can apply for cancellation of removal, but what are the requirements? What are the eligibility requirements for cancellation of removal? What are the eligibility requirements for cancellation of removal? Now, I'm going to list about 5 basic requirements, and I'm going to explain them one by one. And I want you to pay attention because I don't want to be misquoted, because some of them, like I said, this is one area of law that is extremely technical. Now, talking about eligibility requirement, before anyone can apply for legal permanent for cancellation of removal for legal permanent resident, the first requirement is that that person must have been a legal permanent resident for at least 5 years. Must have been a legal permanent resident for at least 5 years. Now, before I go on, because I said, and I'm going to keep saying, that this is a very complicated area of law. What stops the accrual of that 5 years? In most cases, when an NTA, notice to appear, when an NTA is issued or served on the respondent, it usually stops the accrual of time or day or year, as the case may be, for the purpose of cancellation of removal. I remember when we were discussing cancellation of removal for non-permanent resident, I did say that the 10-year requirement will stop as soon as NTA, notice to appear, is served on the respondent. So the 5 year here regarding a green card holder, the issuance, service, or even filing of a notice to appear does not stop the accrual of that 5 years. That is the first thing I want you to pay attention to, because I'm going to discuss when I'm discussing some other eligibility requirements, it may be different. It may even sound contradictory, and that is why it is important to understand what I'm trying to explain here. Now, the requirement that a respondent applying for cancellation of removal for legal permanent resident must have been a legal permanent resident, a green card holder, for at least 5 years. That requirement, the issuance of an NTA, notice to appear, does not stop the accrual of that 5-year counting. In fact, even the removal proceedings itself does not stop the accrual of the 5 years. Let me give a couple of examples so that you understand exactly what I'm trying to say here. The first requirement for anyone applying for cancellation of removal is to be a legal permanent resident for at least 5 years. Now, if someone has been a legal permanent resident for 3 years and then committed an offense and was charged to immigration court, a notice to appear was issued. Now, let's say the person went to immigration court, asserted some relief, maybe the relief was denied, and then the respondent or that person filed an appeal to the BIA, Board of Immigration Appeal. Now, maybe while the appeal was pending, that person has now been a permanent resident for 5 years. Now, not only will the removal proceedings not stop the clock, that person at that moment can actually apply to the BIA to remand the case to enable him or her apply for cancellation of removal for legal permanent resident, because all the years that the case was pending in removal proceedings, they will continue to accrue, they will continue to add up even for this applicant. So the applicant is not going to be prevented from accruing the 5-year legal permanent resident simply because he or she was already in removal proceedings. So for the purpose of these 5 years, the applicant can continue to accrue. That is the first requirement. The second requirement, excuse me, just a minute. The second requirement, which is extremely different from the first requirement, is that the applicant must have been admitted into the United States for at least 7 years. Now, this is where it is tricky. The first requirement says the applicant must have been a permanent resident for at least 5 years. This second requirement is that the applicant must have been admitted into the United States for at least 7 years. At least 7 years. That is the second requirement. Now, admission could be in any status. It could be that the person was admitted into the United States as a permanent resident, as a green card holder. It could be that the person was admitted into the United States as a visitor with a B1, B2 visa. It could be that the person was admitted into the United States maybe as a student, F1 visa. It could be any form of admission, but what it cannot be is IWI. IWI is entry without admission. The person must have been admitted at the port of entry, either airport, seaport, or land port, but the person must have been admitted at the port of entry. So the requirement of 7 years physical presence is different from the requirement of having to be a permanent resident for 5 years. These are two separate requirements, and they have separate laws applied to them. Unlike the first requirement, where I just explained that the issuance of an NTA does not trigger the stop time rule for the purpose of accruing the 5 years. For the purpose of the 7-year physical presence, there are multiple things that stop the time. There are multiple things. In fact, the issuance of an NTA notice to the service, not the issuance, the service of an NTA, the service of a notice to appear will stop the time in this case. The service of a notice to appear will stop the time, will stop the accrual of time. So if somebody has been here, maybe the person came in as a student and then subsequently became a permanent resident for 5 years, but maybe he came in as a student within 1 year, became a permanent resident. So total physical presence, let's say, is 6 years and 10 months. And then a notice to appear was issued. that person will not be eligible for cancellation of removal for legal permanent resident because that person will not be able to satisfy the 7-year physical presence requirement, because as soon as the NTA is issued or served on the respondent, there is an automatic stoppage of time. So they can no longer add any accrual of physical presence for that applicant. Now, another thing, this is very important. This is one of the recent developments in this area of law. The Supreme Court, the United States Supreme Court, recently in 2020 ruled that even if no NTA has been filed, the commission of a crime in itself will stop the time. In other words, if an applicant commits a crime, whether or not that applicant has been convicted, time will stop. That is what the Supreme Court just ruled. In fact, that case, let me see, it's not a case I remember on the top of my head. Yeah, that case is called Barton versus Barr. Barton versus Barr. It is a 2020 Supreme Court decision. It's called Barton versus Barr. So, in other words, before that case, we always rely on conviction, because an accused person is presumed innocent until proven guilty. So it is only when somebody is convicted of a crime that you can actually refer to the person as a criminal. Prior to conviction, the person is only an accused person. But in this case, the Supreme Court said no. As long as that person committed the crime, even if the person was not convicted, time will stop for the purpose of counting the 7-year physical presence requirement for cancellation of removal purpose. So it is very, very important not to mix it up with the first requirement, because they are completely different. And this is a novel thing. In actual fact, since the Supreme Court has made this, maybe I should call it adjustment, all the cancellation of removal cases that I have, partly because of COVID, they are still pending. So we have not been able to see the impact this is going to have on pending cases or even new cases, because, like I said, it's a relatively new decision. And of course, cancellation of removal for permanent resident is not a kind of relief that we seek all the time, because it is not all permanent residents that do commit crime. So it's not an area of law that we do every time. So while waiting for that, I have to explain again the distinction between the first requirement and the second requirement. For the purpose of the first requirement, it is only after there is a final administrative decision by the Board of Immigration Appeal that time can stop for the purpose of accumulating the 5-year legal permanent resident requirement. However, for the purpose of accumulating the 7-year physical requirement, the Supreme Court, in the case of Barton versus Barr, a 2020 case, the Supreme Court has said that even the commission of the offense by itself will stop the time. So even if the respondent is later not convicted, the commission of the crime itself will stop the accrual of time. So that is something that we need to pay attention to. Please, can we have 1 minute break? I need to deal with this call. Welcome back. Apology about that. I just needed to take some water. Yeah, I was talking about cancellation of removal for legal permanent residents. So, the first requirement is that an applicant for cancellation of removal for legal permanent resident must have been a legal permanent resident for 5 years. And these 5 years can continue to accrue even if the applicant is in removal proceedings. The stop time rule does not apply to the requirement of being a green card holder for at least 5 years. So the time can continue to accrue even while the case is pending in in immigration court, or even when the case is pending at the Board of Immigration Appeal, it continues to accrue. However, the second requirement is that the applicant must have been physically present in the United States for at least 7 years. And of course, the applicant must have been admitted. So an applicant who entered the United States without inspection, an applicant who walking through the border will not meet this requirement, because for the 7 year physical presence to be met, an applicant must have been admitted legally into the United States. It doesn't matter what form of admission. It could be B1, B2 visiting visa. It could be H1B visa. It could be F1 student visa. It could be it could even be immigrant visa. For as long as the applicant was admitted at a port of entry, whether it is airport, seaport, or land port, for as long as the applicant is admitted at the port of entry. However, I'm going to spend a lot of time on this 7 year physical presence requirement because it is important. This is the core of one of the core of the requirement for cancellation of removal for legal permanent resident. There are certain things that trigger the stop time rule that stop it. And there are a few exceptions to this stop time rule. One of the first things that trigger the stop time rule is the issuance of NTA, the service of a notice to appear on the applicant. Once a notice to appear is served on the applicant, that 7 year physical presence requirement, the applicant will stop whatever number of years, months, or days the applicant has accrued on the date of the service of the NTA. That is where the clock will stop. So if the applicant has not accrued 7 years on that day, then the applicant cannot meet the requirement. The second thing that triggers the 7 year, the stop rule of the 7 years, it kicks in. In other words, if the applicant has been physically present in the US for 6 months and 11 months and then committed a crime, even if the notice to appear was not issued until 6 months later, that applicant will not be eligible for cancellation of removal for legal permanent resident, because the day of the commission of the crime, according to the Supreme Court, that will be the day that the stop time rule apply. Now, there are a few exceptions to the stop time rule. There are a few exceptions because the Supreme Court actually interpreted Section 212A2 of the Immigration and Nationality Act. Section 212A2, that is the section of the law that listed specifically what is required to be the offenses, the specific offenses that stop the time. And that is why the Supreme Court said that we cannot rely on when the NTA is filed, because the statute specifically listed these offenses. So offenses that are specifically listed in Section 212A2 of the Immigration and Nationality Act, the commission of any of those offenses will automatically trigger the stop time rule. That is what the Supreme Court stated. Now, talking about exception to the stop time rule, The first exception will be if an applicant committed an offense that is not specifically listed in section 212A2. It doesn't matter if it is listed in any other section of the Immigration and Nationality Act, for as long as that offense is not specifically listed in section 212A2, then the stop sign rule will not apply. So the stop time rule will only apply upon the service of the notice to appear. Upon the service of the notice to appear. That is one of the exceptions to the stop time rule. Another exception to the stop time rule is what is called minor offenses. That is, somebody who entered the United States as a minor, maybe as a child under 18, and then if someone entered the United States as a permanent resident or as a child and then committed a petty offense, because that child because if the person is under 18, he or she will be treated as a child and it will come under petty offense exception. Excuse me. So the next one, similar to that, to the petty offense except. Okay, before I go into the next one, still talking about the petty offense exception. This exception will only apply if it is one single offense. If it is one single offense, if it becomes multiple, that is, even if it's a child, if this child committed multiple offenses, not multiple offenses arising out of single incident, but maybe multiple offenses on multiple days, or even the same day but two different offenses. Maybe the person committed assault, and then maybe on the same day the person committed stealing. Those are two separate offenses, except if the stealing was committed in the process of committing the assault, or the assault was committed in the process of committing the stealing. Then we can argue, it's not guaranteed that the judge will buy it, but we can argue that it constitutes a single offense, a single scheme, a multiple offense within a single scheme. But again, I'm not sure whether or not the judge will buy it. But the law is that once there are multiple offenses, then the petty offense exception will not apply. So that will be an exception to the stop time rule. Now, another thing that prevents someone from being eligible for cancellation of removal for legal permanent resident is the commission of drug-related offenses. Immigration law is very harsh when it comes to drug offenses, especially marijuana. Now, there are a few exceptions, maybe a personal use of 30 grams or less. That exception is there too, a personal use of 30 grams or less. Now, I want you to pay attention. Use of marijuana is different from sale or distribution. There is no exception for distribution. It is only the use. And of course, it has to be 30 grams or less before the exception can apply. But if it is more, then the exception will not apply. It is important to understand this. The reason I'm emphasizing this is because of the fact that in the United States today, there are states where the use of medical marijuana is legal. states like Colorado, it is legal. But the fact remains that it is still a federal crime. So even if it is legal in the state where you live, it may be, if it will still be a federal crime. So if you are charged under federal law for either use or distribution, it will be a bar. It will prevent you from being eligible for cancellation of removal for legal permanent resident. So by now, while I keep going, you can start sending in your questions so that we don't waste a lot of time discussing things that may not be what you are expecting me to address. Let's see if questions are coming in. Okay. Oh, this is not a question. Okay, it's just a comment. Okay. Sammy, the good Lord increase you in wisdom and understanding all around. Rest in your passion in Jesus' name, unfailing name. Amen. Okay, thank you. I say amen to the prayers. Okay, the first question, if the cancellation of removal is denied, does that mean I'm no longer permanent resident? Yes, but of course, you will have the right of appeal. So if an immigration judge, if an immigration court deny your request for cancellation of removal, you will no longer be a permanent resident. But of course, you have a right of appeal, so you can still apply appeal to the Board of Immigration Appeal. So it is only after the Board of Immigration Appeal has ruled on the case, that is when it becomes a final decision. That is when it becomes a final administrative order. And from that moment, that is when you are no longer a permanent resident. And that means you will be removed from the United States. That means you'll be removed from the United States. Okay, so let me just continue with the requirement of cancellation of removal for legal permanent resident. I was talking about the offenses, the specific offenses listed in section 212A2 of the Immigration and Nationality Act. So those specific offenses triggers a bar to the accrual of time for the purpose of physical presence requirement. Now, I'm going to state what those specific offenses are. Now, this is the Immigration and Nationality Act. This is the immigration law. So, Section 212 specifically listed those offenses that will trigger a stop time, the stop time rule for the purpose of cancellation of removal. So, the first rule under this section is what is called crime involving moral turpitude. Crime involving moral turpitude. So now, that means that criminal activities that are seen, well, I don't even know how to explain crime involving moral turpitude in a layman's language, because we call it CIMT offense. So I'm trying to see how to explain it in a layman's language. There are some criminal activities that are, like I said, petty offenses. Those ones will not be, maybe criminal activities like maybe alien smuggling, maybe DWI, especially when it is more than one. When it is one, we can still argue that it's not a CIMT offense, but when it becomes multiple, then it becomes a CIMT offense. So I will come back to that later. But for now, let me just list what those offenses are. So crimes involving moral turpitude. The exception to that is political offense, pure political offense. That one will not count. If you are charged with a political offense, that will not count. The next one is violation, a violation of any law or regulation of a state in the United States, either a state or federal law, violation of any law or regulation within the United States or the federal law, or a conspiracy or an attempt to violate those laws. So that is the first um, criminal matter listed in section 212A2. The second one is multiple criminal convictions. It does not matter whether it's a simple offense or a multiple offense. The moment you have multiple criminal convictions, then it triggers the stop time rule. And I think I already mentioned that. Then the third one will be controlled substance traffickers. As I said earlier, the immigration law frowns at drug offenses. So controlled substance traffickers, especially traffickers, users are not, well, for as long as it's a single time use and it's less than 30 grams. If it is marijuana, yes, that will be exemption. But generally for controlled substance traffickers, these are offenses that are specifically listed in 212A2 of the immigration law. The next offense listed is prostitution and commercialized vice. So prostitution, I know that is an adult thing, but if you operate in a state where it is a crime and you are charged with prostitution, it is an offense listed specifically in 212A2, and it will trigger the accrual of the 7-year physical presence. That is the next one. The next offense listed here is certain aliens involved in serious criminal activities who have asserted immunity from prosecution. So if you are if you have been charged with criminal activities in the United States and you try to assert immunity, maybe you have some form of diplomatic immunity and you assert it. Of the next crime specifically listed, foreign government officials who have committed particularly severe violation of religious freedom. Now, this is interesting because this offense does not necessarily have to have been committed in the United States, this particular one. So you may have committed this offense while you are still in your country, in your home country. So if you have been someone who have committed an offense where you limit or you tamper with somebody's religious freedom, maybe somebody you are in a position to prevent people from worshiping whoever they believe in. Maybe you are from an Islamic country and you are preventing people who are Christians, or maybe you are from a Christian country and you are persecuting people who are Muslims, or maybe it may even be the persecution of somebody who didn't even believe in anything. Because in the United States, you have the freedom to worship whatever you believe in, and you also have the freedom not to even worship anything at all, or to even believe in anything at all. So if you have prevented people who didn't believe in anything at all, or who didn't believe in what you believe in, or who didn't believe in your religion, and for that reason you have persecuted them, it does not matter whether these offenses were committed while you are in your home country. you will still be ineligible for cancellation of removal.
What's the
The
principle
next
of that?
offense listed here is significant trafficker in person. That is people who committed human smuggling. Again, this may be, maybe you are dealing with prostitute, you transport one person from one location to another for the purpose of prostitution. For as long as you deal with human trafficking, these are specific offenses listed in INA 21282, and it will trigger the stop time for the purpose of cancellation of removal for legal permanent resident. The next one is money laundering. Money laundering. So if you have committed an offense of money laundering, again, it does not matter whether you have been convicted or not. It does not matter whether you have been convicted or not. All you need to do is to commit the offense for the purpose of this stop time rule. So even if you are not committed, you will still be prevented from being able to accrue the 7-year physical presence for the purpose of cancellation of removal for non-permanent resident. Now, having listed all the all the specific rule, all the specific crimes that triggers the stop time rule, I also want to list some exceptions to these stop time rules, because it is important to understand those who are prevented from accruing the 7-year physical presence from the date of the commission of the offense versus those who are only prevented from accruing the physical presence rule only from the date of service of the notice to appear. So very, very important. So one of those exceptions is that there is something called IRA, Illegal Immigration Reform Act, IRRA. This was an act in 1997 that attempted to reform the immigration law. So if the offense in question was committed before 1997, then the law in place at that time is what we apply. This INA 21282 will not apply. So it is very important to understand that. So if you found yourself in this scenario that we are describing, and you realize that the offense that is disqualifying you, that offense was committed before 1997, or even in 1997, but before the enactment of the IIRA, then all these things that I've listed will not apply to you. It will be an exception because you can still accrue your 7-year physical presence, and this the stop time rule will not apply to you. The next one, apart from the IRA, okay, I think it's only the IRA. I don't think there's any other one. So I want to go to the next requirement for the cancellation itself. I think so far we have only discussed the first two, which is an applicant must have been a legal permanent resident for 5 years. And I said for the purpose of the 5 years, even the period you are in removal proceedings can continue to count. Even if your case has been denied and you file an appeal to the Board of Immigration Appeal, the time can still continue to count because it does not stop until there is a final decision from the Board of Immigration Appeal. The second requirement is the accrual of admission and accrual of 7-year physical presence. And this, I said, you have to be admitted into the United States. It doesn't matter how you are admitted. It could be as a visitor, it could be as a student, it could be anything. However, I have to say this. If you walk in through the border and apply for asylum and you are granted asylum, and then maybe 5 years after becoming a permanent resident, you committed a crime and you are charged into immigration court, you will not be eligible for cancellation of removal for legal permanent resident because you are not admitted. So you will not be able to show the 7-year physical presence. In your case, that 7 year will start counting from the date you became a permanent resident. So even if you have been living in the US for 5 or 10 years before the date you became a permanent resident, it will not count for the purpose of cancellation of removal for legal permanent resident. So I hope that is very clear. That admission is a prerequisite. It is different if you are admitted maybe as a visitor or as in any other status, and then you apply for asylum and you are granted asylum. That is different. You will be able to continue to accrue the legal physical presence. But if you walk in through the border, declare an asylum, and you are granted asylum, for the purpose of this 7-year physical presence, you will not meet the requirement because you will only start accruing the 7 years from the date that you became a legal permanent resident. So that is very, very important. Then let's go to the third requirement. The third requirement for cancellation of removal for legal permanent resident is that the applicant must not have been convicted of aggravated felony. The applicant must not have been convicted of aggravated felony. Now, before I explain this further, I want to go back to the second requirement. That's accrual of 7-year physical presence. Because, like I said, it is the core of this relief. And if we don't get it, we may not be able to present an approvable application before an immigration judge. What I'm trying to say here is that even if you meet the if the stop time rule applied to you, that is, if from the date of the commission of an offense the stop time rule apply, that is different. It is only the stop time rule that is affected. That is different from the eligibility for cancellation of removal, because for the court to determine eligibility, you will still have to have been convicted. So I want us to understand the difference here. The issue here is the commission of crime only affect the stop time rule, only affect the ability to continue to accrue 7 years of physical presence. It does not affect eligibility itself, because eligibility itself, the government will still have to show that you have been convicted of that offense before you can be ineligible to apply for cancellation of removal for permanent resident, assuming that you met the requirement of physical presence at the time the clock stops. So I want to just quickly explain that before we go into the next thing. And like I said, the third requirement is that the applicant must not have been convicted of aggravated felony offenses. Now, what constitutes aggravated felony vary from jurisdiction to jurisdiction. But for the purpose of immigration law is a federal law in the United States, and it is only the federal law that controls. So you may have committed an offense for which the state where the offense was committed did not or does not classify that particular offense as aggravated felony. But for immigration purpose, that offense could have been classified as aggravated felony. Let me give you an example or a simple explanation, the best way I can in a layman's language. Any offense for which the conviction is at least 1 year for immigration purpose is considered aggravated felony. Any offense at all for which a conviction is at least 1 year, 12 months or more is considered aggravated felony. So even if you committed a simple offense, if you don't understand all these little things, it doesn't matter whether you are actually sentenced to jail or you are placed in probation. For the purpose of immigration law, probation and jail carry the same consequence. So if you are granted 12-month probation, it will still be aggravated felony. If you go to jail for 12 months, it will still be aggravated felony. So federal law is completely different from a lot of state laws. And that is why if you find yourself in any of these situations, especially if your case is still pending at a criminal court, you want to make sure that your criminal defense attorney consult with an experienced immigration attorney before you plead to anything. Another thing that I want to say here, talking about aggravated felony, again, the government has the burden to prove that you have actually committed these offenses. But in a situation where you plead guilty, or if you pleaded guilty, then the government will have met its burden. So the burden shifts to you. So the government will not need to prove anything if you plead guilty. So these are basic things that you need to know before, especially if you find yourself ever getting involved in any criminal matter and you are not yet a U.S. citizen. My brother, my sister, I advise you, tell your criminal defense attorney to consult with an experienced immigration attorney so that you understand all these intricacies before you plead to anything. From experience, I've seen people who plead guilty believing that the criminal defense attorney will just tell them that, don't worry, you are not going to go to jail. Just take 12-month probation. A lot of criminal defense attorney, they are only after, their main concern, their main goal is ensuring that their client does not go to jail. But for immigration purpose, it is different. It does not matter whether you go to jail or not. It does not matter whether you are placed in probation or not. It does not matter. What matters is the length. What were you convicted of, and what was the length of the conviction? That is what matters in immigration purpose. I mean, I know someone who was drunk and attempted to park his car in his garage. Unfortunately for him, about the time that he was attempting to park his car into his garage, his wife came out through the garage trying to find out what was going on. And then, of course, he attempted to run into the wife. It was a neighbor, not even the wife. It was a neighbor who called the cops for this guy. And then the police came. They realized that the guy was drunk, and then they arrested him. Now, they charged him for attempted assault on the wife. Remember, the wife didn't call the cops. The wife didn't file any complaint. It was a neighbor who called the cops. The police came. Now they realized that the guy was drunk. Now he was charged with DWI. Now he was charged with attempting to assault the wife. Again, they got a criminal defense attorney whose purpose was just to ensure that the guy didn't go to jail. So at the end of the day, the guy pleaded guilty to the charge. They dropped the charge of DWI, and the guy pleaded guilty to the charge of attempting to injure the wife. Now, this person is in serious trouble because he's not yet a US citizen. He's in serious trouble now. In fact, he was detained. So these are little mistakes that criminal defense attorneys make, but you can't blame them because they don't know, and you cannot give what you don't know. So that is one of the reasons why we are doing this program, so as to educate you, so that you know that if you find yourself committing a crime, do not engage only a criminal defense attorney, but let your attorney consult with an experienced immigration attorney who can advise him or her, so that you don't take a plea bargain that can turn out to put you in jeopardy. So that is the third requirement. The applicant must not have been convicted of aggravated felony offense. Now, it is also important to go further. When we are talking about cancellation of removal for legal permanent resident, there is an element of discretion. Even if you meet all of the requirements, the immigration judge must still exercise discretion in your favor. The immigration judge must still conclude that, okay, you are a desirable person as a permanent resident in the United States. So you still have to convince the judge that your case is approvable in the exercise of discretion. Let the questions keep coming in. Let the questions keep coming in. Okay, I see that we already have a lot of questions. Okay. Question: my green card expired while I was in removal proceedings. Can I renew my green card while I'm waiting for a hearing? Yes. Even if you look at the requirement that I've listed, especially the requirement to be a permanent resident for 5 years, you will see that for a green card holder, you remain a permanent resident until the final administrative decision. And the final administrative decision usually comes from the Board of Immigration Appeal. So the fact that you are in removal proceedings does not mean that you are no longer a permanent resident. You are still a permanent resident. You should apply to renew your green card, file Form I-90, and when you get a receipt notice, you can schedule an InfoPass appointment to have your passport stamped, so that it will show that you are a legal permanent resident, at least for the purpose of employment or for any other purpose, but certainly not for purpose of traveling. Because if you are in removal proceedings and then you travel outside the United States, that will be considered self-deportation, and you may not be allowed to come back into the United States. Next question. Is it risky to apply for cancellation of removal? Well, it's not risky if you met the requirement. The main risk there is understanding the requirement, and that is why I'm spending a lot of time explaining the requirement, especially the requirement of the physical presence. Because if you don't understand that, you may not be eligible, and you may be thinking that you are eligible. I mean, if you look at one of the examples I gave, especially for the purpose of calculating the 7-year physical presence, maybe you enter the United States and you have been here for maybe 10 years. Maybe initially when you entered, assuming that you entered through the port of entry, or maybe from Mexico you cross into El Paso or into California or into Texas, anywhere, and then You live here for 10 years without any legal status. Maybe along the line, maybe you have a child, or there was a kind of a loophole in the law that gave you an opportunity to apply for permanent resident. Let me give you an example of a loophole in the law that can make somebody who entered illegally eligible for adjustment of status. Maybe you are from Mexico or any other country. Maybe you have a brother who has been a US citizen a long time ago. Maybe, this is just an explanation, maybe in year 2000, your brother submitted an I-130 petition for you as a sibling of a US citizen. Now, that type of petition, because it requires visa to be current, and depending on your home country, current visa bulletin for that category, it could be anywhere between 15 years and 30 years waiting period, especially if you are from Mexico, Philippines, India, and which other country? About 4 countries are treated, China, yeah. Mexico, Philippines, India, and China. So if you are from those countries are considered countries with large numbers of immigrants. So if you are from any of those countries, the waiting period may be longer. But even if you are from countries that are not considered high immigrant country, you still have the minimum, at least as at the last time I checked, which was probably last week, the minimum waiting period is about 15 years. So most people, they usually lose patience while waiting. So going back to my example, maybe you have a brother or sister who submitted that type of application on your behalf in year 2000, and then subsequently you decided to walk in through the border, and you maybe in year 2021 maybe in year 2001 or 2002, you decided to walk in through the border. You came in illegally, entry without inspection, and you continue to live here. Maybe you got married, you have children. Maybe along the line, your child, who is a US citizen, turned 21 years old, and then decided to file a petition for you. Ordinarily, you will not be eligible for adjustment of status because you did not come in legally. You will not be eligible for adjustment of status. But guess what? That petition that your brother or your sister filed for you in year 2000, that petition, you can actually use that petition. It doesn't matter whether it was approved or denied. You can actually use that petition to adjust under Section 245I. There's a loophole right there. You can use that petition to apply under Section 245I. Now, if you use that type of petition to apply and you eventually become a legal permanent resident, although you have been living in the US since year 2000 or 2001, from the example I gave, you may have been living in the US from 2001 to now. That is 22 years ago. But maybe you eventually became a permanent resident in year 2020. So that means, or let me say this, maybe you became a permanent resident in 2018. So that means that you will meet the first requirement, which requires you to be a permanent resident for 5 years. You will meet that. But you will not be able to meet the second requirement, which requires you to show physical presence of 7 years. Even though you have been living here since year 2001, you will not be eligible because you entered IWI. You entered without inspection. So all those 20 years you spent here will count for nothing. Or 18 years, it will count for nothing because you are not admitted. So these are the basic things that you need to understand. Immigration law is complex. So that is why if you meet the requirement, yes, it's not risky at all. But if you don't meet the requirement, yes, maybe it is risky. It is risky to apply for any benefit you are not eligible for because it will be denied. And if you don't have any other relief, then you may be ordered removed from the United States. Next question. Can I travel or leave the country during processing of my cancellation of removal case? No, you cannot, because as we stated when we started these deportation defenses, and I've stated it even earlier today, we are talking of people who are in removal proceedings. You don't have the you will not be able to present a defense, a deportation defense, if you are not in removal proceedings. So we are talking of people who are in removal proceedings. So if you are in removal proceedings, that means the government has already given you a charging document called notice to appear. They have already said that they intend to remove you from the United States. If you on your own now decide to remove yourself from the United States by traveling out of the United States, you will not be admitted back. So that is self-deportation. So if you are in removal proceedings, it is not safe to travel. If you do, then you self-deported yourself. Next question. Hello, sir. From what you said, I believe that my own case is weak. Can I request voluntary departure on my own? If so, what is that process like? Well, I don't know whether your case is weak or not, but because I don't have the fact of your case. But of course, if you want to request voluntary departure, that's not a difficult thing. There are three types of voluntary departure. We have a pre-conclusion voluntary departure, we have post-conclusion voluntary departure, and we have bonded voluntary departure. Pre-conclusion voluntary departure, that simply means that you can tell the court or even with the opposing counsel that you want to leave on your own and apply for voluntary departure. So the court will tell you how much time they want to give you. But I think the maximum the court is allowed to grant is 120 days, 4 months. Yeah, that is the maximum that the court is allowed under the law to give you to put your house in order and then voluntarily leave. The second one is post-conclusion voluntary departure. This means that you have already conducted your trial. You have presented all your relief, you have presented your case, and then maybe your case is denied. So at that stage, you can tell the judge that, you know what, I'm not going to fight this anymore. I don't want to file an appeal. All I want is voluntary departure. So the court can tell you, okay, we give you 30 days for you to put your house in order and leave. So they can also give you up to 120 days, which is the maximum. Again, that will depend on the judge. That will depend on whether the government opposes it or not, because some judges or even the opposing lawyer may feel that if you are going to take that, why not do that? Why waste everybody's time? So they may oppose it. So who knows? But usually, except in limited circumstances, it is likely the judge is probably going to grant you if you want voluntary departure. The third type of voluntary departure, which is likely going to be applicable in this case, I use the word likely, not necessarily, and that is bonded voluntary departure. This is because usually for a permanent resident to be deported or to be removed from the United States, a crime will have been involved. And of course, if a crime is involved, that means that the judge or even the opposing party, the government, may not trust you. So they may want you to post a bond to ensure that you actually depart. So they can tell you, okay, we give you 60 days, but you have to post a bond of $5,000 to be sure that you leave. So if you have to post a bond, When you leave, then there is you will have to go to the US embassy in the country where you departed to and show yourself there. They will see you physically, and then they will sign a form to confirm that yes, you are actually outside the United States. Then you send that to ICE and get your money back, the money that you posted as your bond. You get your money back. So it's not difficult to get voluntary departure. The next question: I was given a 204C. They didn't rescind my green card. I'm in removal proceedings. If I believe that I can prove my marriage is real, is it possible to apply for cancellation for LPR? Let me tell you this. Whoever sent this question, I will advise you outside of this podcast, I will advise you to consult with an experienced immigration attorney, because you may have a different relief that is not cancellation of removal. If you already have your green card and your issue is 204C, you may have a completely different relief. There is something called 237A1, 237A1H for legal permanent resident who obtain green card by fraud. So you may be eligible for a completely different relief. Because for the purpose of cancellation of removal, the court is not going to allow you to go into proving your marriage. It is only if the issue of good moral character comes up. Of course, you still have to meet all these other conditions that I listed for the purpose of cancellation of removal. But again, if you know that you meet the requirement, you can apply for it. But in addition, you actually have you may, don't let me say you do, but you may actually have a completely different relief called 237A1H waiver. So I will advise you to consult an experienced immigration attorney to further look into your case. Next question. I have not been convicted of any crime, and I have been here for more than 7 years as a legal permanent resident. So what's the question? Continuation from the 204C. Oh, okay. Okay, let me go back to read the two together then. I was given a 204C. They didn't rescind my green card. I'm in removal proceedings. If I believe that I can prove my marriage is real, is it possible to apply for cancellation for LPR? I have not been convicted of any crime, and I've been here for more than 7 years as a legal permanent resident. Yeah, I think I already answered the question. Yes, you can apply for cancellation of removal if you met all the requirements. But in addition, you may also be eligible for 237A1H waiver. That is a completely different relief. So my advice, have we done anything on 237A1H? We have not. Okay. Maybe maybe we will deal with that in one of our podcasts, 237A1H waiver. But that's a relief that you may be eligible for. So I will advise you to consult with an experienced immigration attorney. Okay. Next question. I believe that my case was rejected due to administrative error. I was told that I did not complete the process correctly, can make the necessary corrections and get another chance. Is this a continuation to? I don't understand this question. Well, whoever sent this question, we need to clarify it because I don't understand. I believe that my case was rejected due to administrative error. What was your case that was rejected? Have you filed a cancellation application that was rejected, or what exactly is this question trying to say? So honestly, I don't understand the question. If you can please expatiate on the question. Um, I believe that my case was rejected due to administration. I need to know what case we are talking about here. I was told, um, okay, yes, it was cancellation of removal. Okay, cancellation of removal, you have to apply in court. Yes, so if you, and there's a procedure. Yeah, you have to apply in court and there's a procedure. Of course, if you don't follow the procedure, they will reject your application. But to answer your question, yes, you can refile if your application was rejected, for as long as your trial has not been done, because you cannot apply for relief after the trial has already been concluded. So you have to apply for relief. When you apply for relief, the court will set it for hearing, and then on the hearing date, the hearing will be conducted. Then the court will rule on the case. So if the hearing has not been conducted, if you still have time, then you can apply. You can reapply. If your application was rejected, you can reapply. So I believe I've been able to answer your question. The next question. Please keep the questions coming. Keep the questions coming. We still have time, so please keep the questions coming so that we can explain this. The next question. Can someone whose sibling petition on his behalf access public funds and other benefit while waiting for approval? I'm not sure what this person mean. I mean, talking about whose sibling petition for, what is your current status? If is this person in the US or outside the US? If the person is in the US, in what status? Are you in legal status or are you out of verified this? Yeah, well, I already answered the question. This person cannot apply for public funds. You cannot access public funds if you are not a legal permanent resident or if you are not a US citizen. Public funds are only meant for legal permanent resident and US citizen. Those are the only people who can apply for public funds. And in some limited situations, if you have been granted a VAWA, if your VAWA petition has been approved, or if you have been given prima facie determination letter, then you may be able to apply for public funds. Other than that, you cannot apply for public funds. Keep the questions coming. Keep the questions coming. We still have about 30 more minutes. Keep the questions coming. If there are areas you want me to expatiate on, please let me know. Keep the questions coming. Keep the questions coming. Ready to answer the questions. Keep them coming. If there are questions you want us to answer, keep them coming. Okay, another question. My spouse is a legal permanent resident, but he was arrested for DWI, and it is not his first. When he finished his sentence, he was then transferred to ICE custody. His green card has not been rescinded yet. So, what's the question? Okay, part 2. Okay. From what you say, I don't think he can apply for cancellation of removal. Is there any waiver or anything else that can be done? I'm a U.S. citizen and we have children that are also U.S. citizens. Well, this is a complicated situation because as I always say during this podcast, and I'm going to repeat again, immigration law is not a one-cap-fits-all. Immigration is not mathematics. It is not 2 plus 2 where you can get 4. When you are talking about immigration law here in the United States, it is case specific. You can have a situation where you can add 2 plus 2 in immigration law and you get 4 as your answer. You can also add 2 plus 2 in immigration law and get 8 as your answer. You can add 2 plus 2 in immigration law and get 7 as your answer. You can add 2 plus 2 in immigration law and get 12 as your answer. So it's not a one cap fits all. This is not something that I'm going to tell you yes or no that you will be eligible for A, you will be eligible for B. But what I will tell you is that legal permanent resident, if you are a legal permanent resident of the United States, or in this case, your spouse is a legal permanent resident of the United States, you are a US citizen, you have children, what I will tell you, even though your husband, as you have already noticed from the explanation, because he has multiple offenses, is probably not going to be eligible for cancellation of removal for legal permanent resident. However, there may be other relief that he may be. For this podcast, I will tell you there are multiple things that a permanent resident may be eligible for, even after the commission of an offense. I'm not saying your husband is eligible because, like I said, I don't have the full fact about your husband's case. So I'm not basing this on your husband's situation. I'm just telling you what a permanent resident may be eligible for. Your husband may be eligible for 2128 waiver. Depending on your peculiar circumstances, your husband may be eligible for 212C. I'm not saying he does or he does not. I don't have the full fact, so I cannot make that determination. Your husband may be eligible for, anyway, he's not going to be eligible for 237A1H because that one has to do specifically with those who obtain green card by fraud. That is what that one is. But again, your husband may be eligible for readjustment. I mean, there are a lot of things that he may be eligible for, but I cannot tell you authoritatively that he is going to be eligible until I have all of the facts of the case. But I do know that there are reliefs for your husband based on the information that you have provided. Next question. Is PhD a pathway to permanent legal residence for F1 visa holder? This is not even relevant to the topic we are discussing today. We are discussing cancellation of removal. But to quickly answer your question, I don't know. Because, as I just said a few minutes ago, immigration is not a one-cap-fits-all. The fact that you have a PhD by itself does not guarantee green card. And the fact that you have a PhD may give you green card. So it depends on the peculiar situation. It is not it's not an arithmetic or a mathematics where you say 2 times 2 you always get 4. No. I've seen somebody with PhD in mathematics from an American university, and her petition was denied. And I've also seen people without a PhD who still were able to get green card. So it's not a one-cap-fits-all. So I will advise you to consult with an experienced immigration attorney who can actually look into your specific situation and tell you if you are eligible for one form of relief or the other, including becoming a legal permanent resident. If this person is new to our podcast, I will advise you, don't we have topic on NIW? Okay, you can go to our YouTube channel and go back and play our video on NIW, National Interest Waiver. So if you believe you are eligible, that is fine. If you want your case, your peculiar case to be looked into, I will advise you that you consult with an experienced immigration attorney. And if you want to consult with me, that is fine. Contact our office. and schedule an appointment. Again, our numbers are 817-883-4495, 817-891-6655, 817 983-4499, 817-274-1144, extension 602, 817-274-1844, extension 603. Any of those things, that will be okay. Next question. My spouse cancellation of removal for LPR was denied and he was removed from the country. Is it possible for him to come back ever for a visit? Well, again, I don't know. Every case is different. I can't tell you yes or no. I don't know how many times I have to say this. You see, what we are doing with this podcast, I don't want listeners or viewers to misunderstand us. What we are doing on this podcast is to educate people, is to provide information, is to prevent people from making mistakes. It is to enlighten people. What we are not doing, we are not looking into specific case. We are not dealing with specific cases, because if we have to do that, we will need to see all of the files. We will need to see all of the documentations. We will need to know everything happening with the case. So I cannot sit down here and tell you this is possible, this is not possible. That is not what we are doing here. If you want your case to be looked into, consult an experienced immigration attorney. If you want to consult with me, that is fine, but that will be looking into your specific case. For this purpose, for the purpose of the podcast, I cannot tell you, yes, your husband can come back. Oh, your wife cannot come. I cannot do that because I don't know. I don't know all of the facts. I don't know any document relating to the case. I don't know why it was why it was removed in the first place. I don't know whether every available relief was presented to the court. I don't know whether there were new relief that came up after he has been removed. There are so many things that I don't know. So I cannot tell you one way or the other. So I want people to understand that, except I want to lie to you, which I'm never going to do. I'm not going to do any of those things. If it is one of those lawyers who is doing this to make money, yes, they can tell you, oh, yes, he can come back. I can't tell you whether he can come back or not without knowing the details of the case. So I hope I've been able to answer that. Next question. On my hearing notice, it says internet-based. What does that mean? How do I appear for the hearing? I'm used to going in person. Well, if your hearing base says internet based, that gives me the impression that you have a lawyer. So it simply means that you should go to your lawyer's office on the hearing date. So that's what that means. It means that they are going to conduct your hearing via WebEx in your lawyer's office. It means your hearing is going to be conducted online on the computer. Usually it's going to be done in your lawyer's office. So if you have a lawyer representing you, then you should go to your lawyer's office for that purpose. Since COVID, some judges avoid in-person contact because they don't want people to give them COVID. So they have been conducting internet-based hearings. So that is what that means. It means that the hearing has to be conducted online. That's what that means. So keep the questions coming. Keep the questions coming. Keep the questions coming. We have about probably 24 more minutes. Yeah, it's still a lot of time. Keep the questions coming. Keep the questions coming. Today we are discussing cancellation of removal for legal permanent residents. Yeah, keep the questions coming in. If you have questions relating to cancellation of removal for legal permanent resident, you can keep the questions coming in. And remember to always join us. Remember to subscribe to our channel so that when we go live, you'll be notified. Remember to invite your family and friends so that they will also partake in this free information. Again, please do not misunderstand what we are doing. What we are doing here is providing information, trying to prevent people from making avoidable mistakes. We are not dealing with specific cases. We are not dealing with individualized cases. So for us to deal with that, we will need to see a lot of documents. We will need to see, to know the details of what has been done in the past, what is yet to be done, the total circumstances, the conviction document, what crime was committed, a lot of things we need to see before we can go into a specific case. So right now we are providing general information. So keep the questions coming. Keep the questions coming. We are discussing removal defenses, and we have discussed cancellation of removal for non-permanent residents. We have discussed cancellation of removal for victims of crime. And today we are discussing cancellation of removal for legal permanent residents, that is green card holders. The requirements are different, so that is why we are taking them one by one so that we don't mix them up. Keep the questions coming. Yeah, I have a next question. Is a work permit needed for a permanent resident that is in removal proceedings if the green card has not been rescinded? No, and I think I've answered this question before. If you are a legal permanent resident, the fact that you are in removal proceedings does not terminate your legal permanent resident. The fact that you are in removal proceedings does not mean you are no longer a green card holder. Your green card remains valid until the end of the administrative process. I use the word administrative process. I didn't say until the end of your case at the immigration court, because even at the end of your case at the immigration court, you still have a right of appeal. And if you choose to exercise that right of appeal by filing an appeal, your case remains pending until the Board of Immigration Appeal, who is the final administrative court, until they rule on the case. If they rule on the case and deny your application, it is from that moment that you are no longer a legal permanent resident. So up until that time, you do not need work authorization because you are still a legal permanent resident of the United States. The only thing you cannot do is travel out, because if you do, that will be considered self-deportation and you may not be allowed back in. But if you have your green card, you can continue to use it while your case is pending in court. So keep the questions coming. That's the last question for now, but keep the questions coming. We still have about 19 more minutes to go. Keep the questions coming. Keep the questions coming so that we answer it before we go for today. Keep the questions coming. Please keep the questions coming. Keep the questions coming. Keep the questions coming. Keep the questions coming. We still have 19 more minutes to go. Please keep the questions coming. So, as I said earlier, the purpose of this podcast is to provide information and to guide our people from making avoidable mistakes. From experience, we have seen a lot of people who make simple, what is considered simple to us, simple mistakes, but costly to the client or to the applicant. So there are little things that makes a big difference. But when you don't know, you don't know. And unfortunately, ignorance of the law is no excuse. So that is why we are trying as much as possible to educate people, and we are doing this free of charge. We are not charging anybody for it. It is free. All you can do for us is to invite your family and friends, invite people so that this information can go around and more people can benefit. It gives us joy when more and more people are able to benefit from what we are doing. So this is not about making money, it is about providing information, because even the Bible says, my people die for lack of knowledge. My people perish for lack of knowledge. So knowledge is key, is vital. And in a country like the United States, simple information can make a big difference between somebody who is in trouble and somebody whose life is going smoothly. And that is why we are playing our part in ensuring that people have access to valuable information. If you have question relating to any of the topics that we have discussed in the past, you can always go back to our YouTube channel and replay the video. We have dealt with a lot of topics in the past, and we are still going to continue. This program is every Wednesday, 12 p.m. Central Standard Time. That is on Wednesday, 12 p.m. Dallas time. And that will be 1 p.m. Eastern time. That will be 10 a.m. Pacific time. And that will be 6 p.m. Nigerian time. So remember to log in and join us every Wednesday. Now, the next question. Can a deportation order be reversed? Yes, on appeal, yes. Even before appeal, yes, a deportation order can be reversed. A deportation order can be reversed. There are several ways to have a deportation order reversed. Several ways. Number one, if the deportation order was granted in absentia, an order in absentia, there are situations where some people are ordered removed in absentia. Maybe, for example, the court sends you a hearing notice. Maybe you have moved, you have changed your address. Unfortunately, you didn't notify the court of the new address. If the court expects to see you on the hearing date and you don't show up, and your lawyer did not show up too, you can be ordered removed in absentia. So in a situation like that, where the removal order is an order in absentia, you can get it removed by first contacting the Office of Chief Counsel, that is the government lawyer that prosecutes immigration cases. You let them know that you didn't receive the hearing notice and you show proof, evidence that you didn't receive it, and you request them to join in your motion to reopen the case. So if they agree to join in your motion to reopen the case, you file what is called joint motion to reopen. If you file joint motion to reopen, then the deportation order will be reversed and the case will be reopened, and you will be given an opportunity to present your relief. That is one way. Even if the government lawyer, the Office of Chief Counsel, even if they decline, they refuse to join in your joint motion to reopen, then get your lawyer to file a motion to reopen. But if you are going to file a motion to reopen that is not a joint motion, you have to present a very solid case. So make sure you get an experienced immigration attorney who can help you prepare a solid case so that the case can be reopened. Because the fact that you didn't get the notice That is not enough. That is not compelling. In fact, most judges will not reopen your case simply because of that. Because you have a responsibility. When you move or change your address, it is your responsibility to notify the court of your new address. So if you fail in your responsibility in notifying the court of your new address, you cannot use that as a reason, as a valid reason for not showing up in court. So some judges are going to deny your motion to reopen. So that is why it is important that you get an experienced immigration attorney who can help you to present a very good case. Now, talking about a motion to reopen, before I go further, I need to say this. A motion to reopen must be filed within 90 days of the removal order. So you cannot come back 2 years after, 3 years after, except if the ground for the motion is in absentia order. If it is an in absentia order, you can file at any time. Whenever you became aware of the order, you can file a motion to reopen. But if it is not an in absentia order, then you have to file your motion to reopen within 90 days of the order you are trying to reopen. That is one way of getting a removal order reversed. The second way to get a removal order reversed is you can file an appeal. As I said earlier, the decision of the immigration judges, their decisions are not final. Immigration judge is a court that adjudicate removal cases, but their decisions are not final. You have the opportunity to appeal to the Board of Immigration Appeal, and of course, if your case succeed, if your appeal succeed, then the removal order is going to be reversed. By the special grace of God, we have done a lot of BIA cases where the removal order was reversed. So yes, you can get the removal order reversed by filing an appeal and presenting a solid appeal case. So those are the ways that you can have your removal order reversed. Next question. You have mentioned Ms. Chavez before. Can you please elaborate on this case and the implication of this ruling? I'm sure that whoever sent this is well familiar with immigration law, because Ms. Chavez is a very important immigration case. Okay, now Ms. Chavez simply say that actually Ms. Chavez is a reaffirmation of Pereira v. Version. There is a case called Pereira v. Version. Now, Pereira versus Session, that's the case. The importance of the case is regarding the stop time rule. Stop time rule. So when we are talking about stop time for the purpose of cancellation of removal, I did say that the applicant must have been a permanent resident for 5 years. I've already explained that the NTA itself does not stop that 5 years. So it does not, Ms. Chavez or Pereira versus Session is not relevant here. However, on the second part, the second requirement, the physical presence requirement, the 7-year physical presence requirement. Now, if the offense, if the crime at issue here is an offense that is listed, specifically listed under 212A2, if the offense is specifically listed, the Supreme Court, the U.S. Supreme Court, has said that the time will stop from the date the offense was committed. Now, if it is an offense that was not specifically listed in 212A2, then Pereira v. Sessions we apply. And of course, Nis Chavez. So what that means is that the issuance of the NTA, for the NTA, the NTA means notice to appear. For the NTA to stop the time, it means that the NTA must be valid. It must contain the date, the time, and the place of hearing. The date, the time, and the place of hearing. Now, if your NTA does not contain any of this, that NTA is not valid. Now, because the Supreme Court, in case of Pereira versus Sessions, that was when the Supreme Court said that for any NTA that does not have any of those three information, the date, the place, and the time of hearing, if those three things are not present, then that notice to appear is not valid. Now, the BIA went ahead after Pereira versus Sessions, and they ruled that, look, even if the NTA is not valid, that error can be cured by a subsequent issuance of a notice of hearing. That if you have a defective notice to appear, if the court subsequently issues a notice of hearing which has the information of the date, the place, and the time of hearing, that notice of hearing will cure the defect in the NTA. In Nis Chavez went back to court, and that case went back to the Supreme Court. And the Supreme Court said that the BIA was wrong, that a defective NTA cannot be cured by a subsequent notice of hearing, because an NTA, the law requires that the NTA must be one single document. So any subsequent notice of hearing cannot cure the defect in the NTA. That is what Nis Chavez is all about. Now, having said this, I want to revisit the question that says, there was a question that was, there was a question that says, can a deportation order be reversed? I want to revisit that question. Yes, it is true we have Nis Chavez. It is also true that we have Pereira versus Sessions. However, if at the time you were ordered removed, go back and look at your NTA, the notice to appear. If your notice to appear does not have the information of date and time, it means that the entire process is invalid, because you cannot build something on nothing. So if the NTA is not valid, the entire immigration proceedings, the removal order, everything becomes invalid. So you have to act on time, because again, the question is, you can't sleep on your right. After some time, you will no longer be eligible to revisit it. But if you still, because Nis Chavez was just last year, 2022. Pereira versus Sessions was probably 2018 or so, either 2018 or 2019. But Nis Chavez was 2022. So if you look at your notice to appear and you realize that it does not have the date, time, and place of hearing, that notice to appear is invalid. And it simply means that you can still go back to challenge your removal order, because you cannot build, the government cannot build something on nothing. So if you are ordered removed based on a defective NTA, you will have the opportunity to go back to reopen the case, present your case of your eligibility for removal or for cancellation of removal. Because what that means is that throughout the process of the proceedings, you will continue to accrue the physical presence requirement. So you will not be, they cannot use that against you if the NTA is not valid. So next question. My mother does not speak English very well. Can I act as an interpreter or do they have them available? Well, in the past, yes, you could have acted as your interpreter, but nowadays they do not allow family members to act as interpreters. Immigration on their own will provide interpreter. It doesn't matter what language your mother speaks. Immigration will provide interpreter right now. If you are in removal proceedings, you have to provide advance notice. You need to let them. Usually, the immigration judge will ask you, what language are you fluent in? And if your case is set for hearing, they will specifically ask you, what language do you want to, in what language do you want to conduct the hearing? So if you want to conduct the hearing in English, the hearing will go on in English. If you want to conduct the hearing in any language, for as long as that language is spoken in any part of the world, I can assure you there will be interpreter for you. So you are not going to be allowed to provide your own interpreter. They used to do that in the past, but they no longer do that now. So keep the questions coming. We have a few more minutes. If we are able to get questions in before 2 p.m., we will still answer it. But if there is none before that time, we will end once it is 2 p.m. But if you have questions relating to today's topic, keep them coming. Today we were discussing removal defenses. It's a continuation of a series of topics that we started a couple of weeks ago. So we are discussing removal defenses. 2 weeks ago, we discussed a cancellation of removal for non-permanent resident. Last week, we discussed cancellation of removal for victims of criminal activities. And today, we are discussing cancellation of removal for legal permanent resident. So, okay, I think I have a few more questions here. Can asylee travel out of the USA with green card? Yes, if you already have a green card, you are no longer an asylee. So you need to understand that. An asylee is different from a green card holder. A permanent resident is a permanent resident. It doesn't matter how you obtain it, whether you obtain it through asylum or through family base, through employment, or even through self-petition. It is immaterial. Once you are a permanent resident, you are a permanent resident. Yes, you can travel out of the US as a permanent resident. However, I will not advise you to travel to your home country where you obtain asylum from, because if your ground for obtaining asylum is that your life is not going to be safe in your home country, and then you become a permanent resident, then you started traveling to that country, then there will be a presumption that your fear no longer exists or never existed. So you don't want to put yourself in jeopardy. So I will advise you not to travel to your home country until at least you become a US citizen. Once you become a US citizen, it will not matter. You can travel to any part of the globe that you like. So the last question for today, this is 2 p.m. already, but because we already promised to answer any question that came in before 2 p.m., so I will still go ahead and answer the question. My mother does not speak English very well. Can I act as an interpreter? I thought I already answered this question before. I already answered this question, so there is no additional question here. So we have answered all the questions for today, and today we'll be rounding up for this session. Again, this is Dr. Olu Asekun here. By the special grace of God, I am knowledgeable with United States immigration law, and it is my desire to transfer this knowledge to as many people as possible, especially because we see from experience that people make what I consider avoidable mistakes. So this program is to prevent avoidable mistakes. It is to educate people. So we do this every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That will be 10 a.m. Pacific Time, and that will be 6 p.m. Nigerian Time. So this program is free of charge. So the only thing you can do to show appreciation is to invite your family and friends so that as many people as possible will also benefit from this, because it will not be fair for you to obtain all this information and you keep the information to yourself. You do not share it with other people. It is only fair so that as you are avoiding mistakes, you also encourage or enable or give others the opportunity to avoid mistakes as well. Immigration law is complex. It's channel or Facebook channel. Click on the subscription button so that whenever we go live, you'll be notified. That is the only thing that is required of you. Join us again next week. By God's grace, we are still continuing our deportation defense cases. But of course, if you have topics that you think is valuable to you that you want us to discuss, contact us through our WhatsApp number. Send in the topics. We'll consider it. I believe our WhatsApp number is 817-983-4499. Is that the right number? The dedicated line for this WhatsApp. Okay, what is that number, please? Okay, I think the dedicated line for the podcast is 817-883-4495. 817-883-4495. So if there is a topic that we have not discussed in the past that you want us to discuss, feel free to send message to that number. It's a dedicated line for this podcast. Send message to that number. Tell us the topic you want us to discuss, and I assure you we will discuss it and give you and others the opportunity to benefit from this live podcast. Again, it was nice talking to you today. See you again next Wednesday, God's willing. Bye.
They work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So, I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. If you do research, you will learn a lot of stuff. There are a lot of immigration rules some people don't look at. There are loopholes there, and sometimes they purposely put them there. So it's research, and it's using those research to help a lot of people. Not just me. It is not just me. It is a lot of people here many people here that he has helped. Many people. Sometimes it doesn't even charge them. When it comes to the point that it doesn't even charge them. So yes, if you are looking for an immigration lawyer, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, I will say it. Dr. Asekun is there, I will just say it. So that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have. My first impression was that he was a man that you can rely on. They work with me, you know, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So, yeah, I can see the relationship was good working with his staff. People give me encouragement, but
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I said, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Another interesting thing about